So thank you to Alex and all at LegalEdCon. It's a huge privilege to be able to talk to you about some of the work that we're doing in Oxford about how legal education may need to adapt in the 21st century. Our research is part of a broader Oxford-wide project called Unlocking the Potential of Artificial Intelligence for English Law, drawing together researchers from the Said Business School, the Department of Computer Science, Education and Economics, and of course the Faculty of Law. Together, the project is examining a series of issues around AI and digital technology, including the rise of new business models and legal services, the rise of digital justice, the frontiers of AI in legal reasoning, in other words, precisely what can be done by the AI from a computer science perspective, the coordination of skill investment and technology transfer, the ecosystems for law tech and innovation, and in our case, with my co-investigator, Professor Hewitt Keep from the Department of Education, and our research fellow Dr. Václav Janeček from the Faculty of Law, the future of law and technology education. Our research stream explores the impact of AI on education and training in the legal sector, but actually much of what we're looking at fits with current thinking about changes in the skills necessary for a 21st century lawyer more generally. Our research on legal education has taken two forms. First, we've conducted a series of semi-structured 45 to 60-minute interviews with 19 subjects from a range of professional organisations, 9 medium to large-sized law firms, 3 such tech firms, as well as the Bar, a legal information publisher and a law library. The aim of the interviews was to understand the knowledge and skills gaps that could prevent legal professionals from enhancing their legal services through the use of digital technology. Second, alongside those interviews, this academic year we have designed and taught for the first time an experimental course in law and computer science, jointly with our colleague Professor Tom Mellom from the Department of Computer Science. This course involved 12 master's level students from each discipline attending 16 two-hour lecture seminars. In the first term, these covered issues relating to the use of technology in legal practice, while in the second term, we covered issues of substantive law arising from the use of digital technology in specific areas of law such as employment law, competition law, and so on. But in addition to these theoretical sessions, students were also put into groups of 6, 3 from each discipline, to produce a pilot project based on blockchain technology for presentation in a pitch-like session to experts from the profession. So, having conducted these two forms of research, what were our results? Well, starting with our interviews, we have identified 5 interlocking areas in which our respondees felt that there was a need for further education and training. The first of these related to differences in mindset between lawyers and computer scientists. Second, our respondees told us that lawyers need to be taught to recognise all the data that flows through their fingers as such and to recognise its value. So lawyers need to be taught to capture data along the way and think about themselves as producers of data that can be read by machines. Third, our respondees felt that there was a need for lawyers to adopt a more agile or design-oriented approach when helping their clients. In other words, rather than simply solving problems on the basis of their existing legal knowledge, they needed to be trained to think about how they were solving the problem and whether any part of that process could be assisted, augmented, or automated by the use of technology. Fourth, our interviewees thought that lawyers of the future would need greater commercial awareness. The pressure would always be there to do things more cheaply, but it's also necessary to think about what the downsides of that cheaper option might be. And finally, there was a strong sense that lawyers would need to understand the law and ethics that might be applied to digital technology in the future. Now, many of these results from our interviews strongly echoed what we discovered by running the Law and Computer Science course. Mindset was really important here too. For example, we found that our law students on the practical projects would say, "Oh, we can't do that." And the computer scientists would say, "Yes, we can. Look, you just do this." And of course, the law students didn't mean can't, they meant shouldn't. It wasn't okay within the legal regulations. We also discovered that teaching the students from both disciplines together and encouraging them to interact with each other really helped to bridge that gap and make both cohorts more bilingual. Thus, as one computer science student put it, it allows one to really take a step back on the code, the maths, and ask ourselves higher level questions. Interacting with lawyers permitted us, that is computer scientists, to confront and compare our point of view and reflect on our own knowledge and mindset, but also understand how our discipline is perceived by another. I really believe these kinds of reflections are crucial for computer scientists, and traditional computer science courses could not have provided them. Similarly, one law student said, "I was also grateful to be able to speak to and ask computer scientists about the technicalities of certain codes, among other technical discussions." While another law student told us that the worst aspect of the interdisciplinary coursework with my peers from my cohort lies in the differences in methodology, language and culture of law and computer science. And this accounted for why it was, at some points, difficult for us to agree on some salient issues. Happily, this is part of the training, and I developed new skills in dealing with interdisciplinary issues. We also discovered that the practical project was at least as important as the theoretical sessions in this respect, probably more so. Thus, one law student told us that the best aspect of the interdisciplinary coursework with the peers from my cohort is the practical project. This project exposed me to why and how law and computer science should collaborate in developing emerging technologies. For instance, in the course of the project, the lawyers on the team consistently assess some of the technical solutions proposed by the computer scientists and how it will fit into the legal framework with less friction. We also found that this practical aspect of the course also helped to develop our students' mental agility, their design thinking and commercial awareness. However, none of this is to suggest that the core of what we do on a university law degree has necessarily to change. It's clear from all our research that core legal skills are still central and vital. Thus, as Spencer, Smith and Suskind all point out, the twist to the tale is that it remains important to qualify as a lawyer and have a strong base of legal black-letter law expertise. Legal responses to technology require an understanding of the technology, but also of how fields such as tort law, public law, employment law, competition law, and so on should respond to it. That requires a detailed understanding of the law as well as of the technology. As one interviewee told us, it's so much fun training a model and seeing it make predictions that are accurate, but the problem is the better at it you get, the more dangerous it can be. And of course, reflecting on the law through the lens of another subject can give you a new perspective on the law itself. One law student on the course told us that the course allowed for a conversation about the law with students from another discipline. And I honestly feel, they said, that this increased my personal understanding of the law by leaps and bounds. In other words, in order to fulfil the requirement of that fifth area of learning needs as identified through our interviews, that is, to provide lawyers with a better understanding of the law and ethics relating to digital technology, we need to ensure that law students are good lawyers first and foremost. So what does all this mean for the future of legal education? Well, inevitably, we approach that question particularly from the perspective of a university, but not exclusively so, and our conclusions do also have implications for legal practice and L&D departments within the professions too, because as I'll say in a moment, learning does not stop with a lawyer's initial qualification. First, it's clear that at university level, we need to keep ensuring that our graduates develop a deep, but also a critical and a normative understanding of the law. They need to understand what the law currently is, but also what it should be. And in addition to this core function, there is also capacity for courses such as law and computer science to produce students who are not only more bilingual in terms of their knowledge of another discipline, but who will also have other skills such as the ability to work in a team in an agile, more design-focused way. And universities' inherently interdisciplinary nature makes them ideally placed to achieve this. But as well as increasing interaction between disciplines, it's also clear from our research that it's also hugely beneficial to increase the interaction between academia and practice. Thus, another survey carried out by one of the other research streams of the Oxford project in collaboration with the Law Society established that if lawyers want a greater understanding of the application of technology to the practice of law from taking a course, then training provided by an external provider would be by far their most popular option for that. So CPD courses provided by universities could therefore fill some of the existing education gaps in a research-led, critical and normative way. This is so whether, as some of our interviewees suggested, we end up moving in some instances towards a whole new career structure for legal technologists, or whether it happens in a more piecemeal fashion as people retrain gradually throughout their careers. As a result, our next task in our part of the research project is to move from designing CPD training for those already in practice in the light of our experiences of the student course. And of course, inevitably at the moment, this will be in an online format. But equally, the Law and Computer Science course very much benefited from participation by those in practice, as indeed do many of the law faculty's other courses, and so this can also provide a source of interaction between academia and practice. In other words, our hope is that in the future we can move beyond the idea of university alumni who have graduated and parted with their place of academic learning towards a more ongoing relationship with our students, providing them with further, potentially interdisciplinary training for subsequent stages of their careers, and ensuring that our less experienced students benefit from the greater experience of those already in practice in return. Thank you.